Professor Rubenstein.
Yes, I'd be interested in pursuing the concept, the first area of change that George raised, which is the section itself, section 128. In the pre-2020 summit that the Jewish community had with the members of the committees, one of the issues that came up in our governance stream was about changing the process of change, and there was quite a lot of support from the group in terms of that idea, seeing that as problematic. I see Professor Saunders shaking her head, and George also raised that as an area that he was not enthusiastic about, but I'd be interested in developing that discussion a little more. George, do you have the actual numbers of those referenda that had been passed by a majority of people but not a majority of states? And is it?
I do. There's 5 that would have been enacted or passed if we did not have the double majority requirement. Yes. So, it's a significant number, but it's also interesting that one of those was actually a referendum to remove the double majority requirement, which only got 3 out of 6 states. So it failed itself on that, and it demonstrates the difficulties in doing it. Of course, it fails in part because smaller states identify, as with Leslie's examples, the fact that they do not want to lose their influence through having that. So it's a really difficult thing to get through unless you can convince smaller states to give up their power, and why would they?
Yes. I don't know if any of the members of the committee have any responses to that.
Professor Rubenstein first, and then Professor Winters.
Yes, if I could just make a further contribution on section 44.1. This committee, I think under the chairmanship of the Honourable Kevin Andrews, looked at section 44, aspects of section 44 in 1997, and did recommend that section 44.1 be repealed and that issues to do with loyalty and conflict of allegiance be dealt with in Parliament. Can I say that that's been made even more poignant since the decision in Sykes and Cleary, of course, because of the amendments to the Australian Citizenship Act in 2002. So at the time of Sykes and Cleary, of course, dual citizenship was only in existence for those who had a former citizenship and took up Australian citizenship or had it by virtue of descent. Whereas from 2002, anybody who takes up a new citizenship no longer loses their Australian citizenship. So the issue of dual citizenship has grown within this country, and as a matter of representative democracy, do we really want to disqualify the significant numbers of people who are dual citizens and are rightly dual citizens in a cosmopolitan and globalised world? So I think that there would be the capacity to make very strong case to all of the Australian people that the issue of dual citizenship wouldn't necessarily be one that is deserving of disqualification, and that there might be ways of dealing with direct conflicts that are not bound in disqualification.
Citizenship. Professor Rubenstein, you said that we're disqualifying people who've got dual citizenship from running for Parliament. We're not. We're actually asking them, and I was in this position, and other members of Parliament were as well, to make a choice. And there are, whether we like it or not, there are different standards expected of the legislators in the federal parliament, whether they deal with potential, perceived, imagined conflicts of interest, for example, with regards to financial affairs. And everything has to be seen to be above board because it goes to the very confidence that people have in their members of parliament. So we're not actually disqualifying people, we're asking them to make a choice. And I think there's a very different standard and a different expectation of members of parliament, because it does raise very real questions, does it not, about actual conflict. We deal with issues, whether they're in regards to the treaties we sign, whether it's in regards to our foreign policy or other legislation. There are very real areas where conflict can arise that can't be foreseen simply through some legislative mechanism. And it's a very minimum requirement, I would have thought, for anyone who wants to make laws for the nation and the Australian people.
This is a good example of how this would be a really interesting discussion to have across the board, because I disagree with you on 2 levels. One is the formal aspect of renouncing another citizenship and what impact that really has on one's sense of connection to that other country, and whether...
From my perspective, it had none.
It had no impact on your sense of connection. So can you give me the example of
the
other...
fact that I had to renounce my Greek citizenship that I never applied for, but it's one of those examples where you're automatically given it,
Yes.
that I had to write away, meant that there was an inconvenience that I
Yes.
could not apply for an EU passport. But I was quite happy to give that up.
Yes.
I, like many others who are first-generation Australians, feel totally comfortable with their family heritage and history and connection. And personally, I thought the calling and the responsibility being a Member of Parliament was far more significant than formally holding citizenship of another country.
And that's your situation, but there might be other people who have a stronger connection to their other citizenship, which may not be at all affected by the formal renunciation of that, but they may still have that continuing affection, association, sense of commitment in ways other than the practical consequences that come
But
from
if that
holding
commitment,
that
at what point could that commitment perhaps conflict with their commitment to make laws in the interests of Australia and their electorate and Australians?
It could very well in any...
That's my
I
problem.
suppose the argument is if it conflicted, then the electors could take
it into
vengeance
account.
at the
Yeah.
next election because it'll be a matter of public
That's
record.
assuming they know all of the dozens or hundreds of pieces of legislation that member has voted on, which is impossible.
Well,
themselves and their family.
yes. But in some ways it makes more transparent the issue that Mr Melham just made, because if you've renounced it but you still have that continuing connection, people don't necessarily have the capacity to know that. But if there was a register set up which listed people's other citizenships, if there was some discussion about a trade issue with the country of which that person is also a citizen, there'd be a way in terms of transparency of making other members of Parliament hold that member to account in their decision-making process. Were they making that in the best interests of Australia, or was there some other allegiance that was involved?
There are many decisions that are made that are not recorded, that are not formal, but symbolically it is quite an important step. Just as citizenship ceremonies are formally an important step and a very special step that people take, and they take it extremely seriously, having been to many of them. In the same way, the actual renunciation is a clear signal to that wannabe Member of Parliament that, hey, you're doing something that clearly demonstrates where your primary allegiance is.
I think a commitment to actually run for Parliament and be a Member of Parliament shows a significant commitment to the country.
Not necessarily.
And I think, and I think that.
And I think most. And
But I think this shows the very lively debate that I'd be very happy to continue in a much more public and national way. But I do think that in a globalised world, we can think much more positively about dual citizenship and not seeing it as undermining Australia. And perhaps to end off my contribution, I always make the distinction of people who see citizenship like marriage or see citizenship like parenting. You can have more than one child and have a commitment to each of them without that undermining necessarily any of the other.
I agree with you.
If I could, Professor Rubenstein?
Can I, on that same note, bring to the discussion one of the ideas that came from the governance stream in the Jewish 2020 discussions. Associate Professor Mark Baker, who heads up the Centre for Jewish Civilisation at Monash University, who is not a lawyer but was on the governance stream and chose to be on the governance stream because his belief is that there needs to be a meta-narrative that speaks to the people in the Constitution, and talked about the preamble as being one framework for doing so, and used actually the story of Passover, which of course is the very reason why there was this special Jewish pre-summit, as a nice parallel to thinking about this more broadly, because of course at each Passover families get together to tell the story of the exodus of the Jews from Egypt, and as he pointed out, Jews from all different persuasions can connect to that story at many, many different levels, so that there's capacity in a story to speak to different understandings of freedom and various ideas that it encapsulates. So too, he was saying, we as Australians should be able together to come to a meta-narrative that speaks to all Australians, and of course starting with the Aboriginal and Torres Strait Islander story as their starting point to that story. And I found that very persuasive in thinking also more broadly about the Constitution speaking to the people and involving the people, and being a starting point to then launch into the way that then is expressed, as we can talk about later, in terms of citizenship and what that means more substantively in the content of the Constitution. Thank you, Chair. I just wanted to raise in the context of representation whether Professors Perrett and O'Donoghue and whether Ms Thomas have heard of John Chesterman's suggestion of another creative way of including Indigenous Australians in decision-making and representation without constitutional change. And I think, and you might be able to correct me or others around the table, that it was setting up an executive council, a special Indigenous executive council. So just as all legislation needs to be signed off by the executive council before it receives assent, you could include a requirement that legislation also be signed off by an Indigenous executive council, and that if the Parliament, and if it chose not to sign off, that Parliament would then need to respond to the whole of Parliament to explain why it wasn't taking into account the views of the Indigenous Council. And I just thought it was quite a creative way of thinking beyond our traditional ways of representation, and whether you'd had any thoughts.
Would that be for all legislation?
Well, there was a discussion as to whether it would be for only legislation that had an impact on them as Indigenous Australians, or whether more broadly on all. But that, I think that was part of the distinction.
Last topic for the day, the fifth session of the day on citizenship and human rights, and I'm going to ask Professor Kim Rubenstein to introduce that topic.
Thank you very much, Chair. I'm delighted to start off the discussion on this session on citizenship and human rights. And as I think we've seen through the course of the day, that the topic and the subject matter of citizenship and certainly human rights is one that's been expressed and discussed in some way to now. So this gives us an opportunity to fully, I think, engage with some really important and quite substantive issues in relation to the Constitution and potential change. And the starting point, of course, when we think about citizenship is, as has been mentioned before, it is not, Australian citizenship is not a term that you find in the Australian Constitution. We do, of course, see the reference to citizenship of another country, which came up in the context of the discussion of section 44(1) and disqualification from Parliament. But whilst there's no reference to Australian citizenship, and this is something that we'll come back to in terms of the need for having that, there are, of course, references to membership of the Australian community throughout the Constitution, but in different ways. So the covering clauses and other sections, such as sections 7 and 24, refer to the people of the Commonwealth or the people of the states in relation to choosing senators and members respectively. Section 34 further raises a concept of membership of the community in prescribing that the qualification for being a member of the House of Reps is that the person is a subject of the Queen, subject to Parliament, until Parliament otherwise provides. But there was that reference to subject of the Queen, and there is in the Constitution. And then, importantly, section 117 is the other section that refers to membership in saying that a subject of the Queen, resident in any state, shall not be subject in any other state to any disability or discrimination, which would not be equally applicable to him if he were a subject of the Queen resident in such other state. So, of course, at the time of Federation, the status of people in Australia who had full membership was the status of British subject or subject of the Queen. And those who were not British subjects were aliens. And it's that terminology around which our Constitution revolves in terms of membership. And a point that I think is still continuing to be significant in terms of public policy and the discussion about membership of the Australian community, I think stems and has its source very much in the fact that membership is really defined in a negative sense through alienage, rather than through a positive statement of who we are as an Australian people and who the Australian Constitution speaks to in terms of membership of the Australian community. And I think that is something that is really deserving of serious attention and change. I think, though, that we have to be quite careful, and this might come out more clearly when we look at rights, in our definitions, if we think of defining citizenship in the Constitution, in terms of membership of the Australian community. And that perhaps one way of thinking of it is enlarging and perhaps defining people of the Commonwealth to include citizenship, and I'll perhaps go into that in more detail when we look at rights, because there is a danger in the definitions of citizenship, and certainly legal citizenship, that there is the potential to exclude people who live within the Australian community permanently, but who have not become full citizens in a legal sense, to be treated differently in ways that may not be appropriate according to rights standards. And a good example in terms of current public policy, of course, are those individuals who have lived all of their lives, in some cases someone who was 27 days old when they came to Australia, lived all their life in Australia, but have the potential to be removed from Australia by virtue of the fact that they haven't taken out formal citizenship, and whether those are appropriate rights standards that should apply within a constitutional understanding of membership of the community. But that's possibly, and that's perhaps, you know, for further discussion when we get to definitions. I do want to make the point, though, that even though British subject was the status of individuals at the time of federation, there was quite an elaborate discussion about citizenship in the constitutional conventions, because John Quick, who was a member of the convention, was very keen to actually have a power over citizenship in section 51, and also a reference to Australian citizenship in section 117. And that attempt was rejected for a range of reasons, which I've written about elsewhere, but very much influenced by immigration policy at the time. And one of the strong themes I think we've seen in Australian public policy in relation to citizenship is the linking of immigration to citizenship, again, which is another issue in terms of how we go about defining citizenship in the Constitution. In the 1999 referendum, there was, of course, with the move to a republic and the whole notion of an Australian citizen being an Australian head of state, a realisation that there would be a need to include citizenship in the Constitution. And the Constitution Alteration Establishment of Republic Bill, which was introduced into Parliament in 1998, provided for the removal of the words subject of the Queen in section 117 of the Constitution, and their replacement with the words an Australian citizen. And in the list of definitions in the bill, an Australian citizen was defined as a person who is an Australian citizen according to the laws made by the Parliament. But there was no inclusion at that time of an amendment to section 51 to include an express power over citizenship, although it could be argued that the insertion of such a definition implicitly gave the Commonwealth Parliament power to make laws over citizenship. And in relation more broadly to section 51, in the fact that there is, of course, an Australian Citizenship Act, the understanding generally is that the Commonwealth gets its power through the Naturalisation and Aliens Head of Power, and also more broadly through an implied nationhood power in relation to being able to define who its members are. Just lastly, before we get to move on to the human rights aspect of it, the 1998 Constitutional Commission also considered citizenship in its deliberations, and recommended that section 51 be altered to encompass nationality, citizenship, naturalisation and aliens, so to use the word citizenship in that head of power specifically, so as to make clear that the Commonwealth definitely had capacity in the area. But it also, the Rights Committee of the Commission had proposed an amendment of the Constitution to include a definition of citizenship, and it suggested a section which I'll read out to you. It said, all persons who are 1, born in Australia, 2, natural born or adopted children of an Australian citizen, 3, naturalised as Australians, are citizens of Australia and shall not be deprived of citizenship except in accordance with the procedure prescribed by law, which complies with the principles of fairness and natural justice. I think that's quite interesting because that's the 1988 Commission's, the Rights Committee's recommendation. The Commission's final report didn't actually adopt that in its recommendations. But what is also interesting is at that time, in 1988, amendments had already been made to the Citizenship Act, changing that natural-born right to citizenship. So in up until 1986, birth in Australia was sufficient under the Citizenship Act to give you citizenship. But after 1986, they changed it that you needed a, excuse me, that you needed a permanent resident or Australian citizen parent, as well as your birth in the country, to entitle you to automatic citizenship. So there's been a change in legislation in terms of the right to automatic citizenship. Birth is not sufficient in itself, yet the recommendation at that time, and certainly something that would need to be discussed in defining citizenship, is whether we would revisit the categories or the entitlement to automatic citizenship by birth in Australia, which I think would raise very interesting questions, linking back to my earlier suggestion that a lot of citizenship discussion is linked into immigration policy, rather than thinking much more broadly about what we believe citizenship as a concept should mean for all Australians, not just for immigration purposes. We've already covered or raised for discussion the question of dual citizenship, but just to repeat again that as a matter of public policy, there has been a strong move in the statutory sense to accepting dual citizenship. And my own view, as I expressed earlier, is that that should lead to the repeal of section 44(1) and looking at ways to enable and enhance representative democracy for all Australians, given the large contingent of dual citizens. Moving on then within that context to the question of rights within the Constitution, and to make the point a little bit more strongly about how we have to be careful in the way we define citizenship, or what the consequences of those definitions are for rights. To start off with purely just thinking of it as citizenship rights in my last few minutes, the bottom line is given there is no reference to citizenship, there is also no reference to any citizenship rights. So if we think in the current framework of the rights that we attribute to citizenship, they are rights that come from legislation. So the Electoral Act is the act that gives citizens the right to vote and, of course, the duty to vote. It's the Migration Act that gives citizens the right to free entry in and out of the country. But those are legislative rights that are able to be changed. And indeed, in argument before the High Court recently, the Solicitor General was making the point that it would be within the power of the Commonwealth to restrict Australian citizens from re-entry into Australia if the Parliament so determined. So in other words, there is no protection of that fundamental right that I think most of us would agree citizens have to live in their country of citizenship.
It's a dangerous move for the Parliament to enact that.
It would be, but it's something that is constitutionally capable.
Maybe you could recommend it to the government.
So he argued that, but it hasn't been...
No, it hasn't, but he was arguing it, and the point is that within our constitutional structure there is no protection of rights that we think of as inherent in citizenship. And similarly, it's open to discussion as to how well voting rights are protected in the Constitution. So basic rights that we think of as civics and citizenship rights are not in our constitutional document. If we look at the rights that are in the document, and as the point's been made several times, this Constitution as it was framed was not framed within the context of the thinking of protection of rights by constitutions, but there are in fact references, and in relation to Mr Perrett's earlier reference to there not being founding mothers, there were in fact founding mothers who weren't present at the actual conventions but influenced the convention debates. And Section 41 of the Constitution is Section 41 of the Constitution is a perfect example of the influence of those women who were politically active at the time, who insisted that the representatives from South Australia and then Western Australia protect the right to vote that women in South Australia and Western Australia had received by the time of Federation, and their right to vote, of course, was protected through Section 41 of the Constitution, which, of course, says that no adult person who has or acquires a right to vote at elections for the Houses of the State shall, while that right continues, be prevented by any law of the Commonwealth from voting at elections for either House of the Parliament of the Commonwealth. Now, that strong political action by the women of the 1890s ended up being something that led to the disadvantage of this section when the High Court in Ex Parte Sitka read down Section 41, to say that it no longer had any value after 1902, when women throughout Australia, white women I should add, throughout Australia, because it specifically disenfranchised Indigenous women, but the 1902 Commonwealth Electoral Act enfranchised white women, and the High Court said that that was part of their understanding of why Section 41 no longer had any relevance. And there were other federal arguments as part of that as well. But it's an example of one of the clear rights statements in the Constitution which has been read down, and so that there isn't a strong reference to voting rights. And Section 7 and 24, of course, enable the people of the states and Commonwealth to elect their representatives. But again, we could have a much clearer statement about the right to vote in the Constitution. But then to the broader question of what other rights in terms of human rights we should think about, and that leads to thinking more broadly beyond civil and political rights to social and economic rights, and whether they should be rights that should be protected, and then the more current debate as to whether rights should be protected by the Constitution per se, or whether we should be looking at charters or legislative bills of rights. But I'm also mindful of Professor Berendt's comment earlier that we don't have to be thinking of them as mutually exclusive concepts. We could be thinking of having some core rights in the Constitution as well as a charter, and I think that that is a very positive reminder to us of thinking about these issues. And then finally, in some of the discussion that has been around through the 2020 conference or in anticipation of it, in thinking about charters of rights and the possibility of having declarations of incompatibility with rights rather than having determinative decisions about rights violation, there's been some discussion as to how that might sit within our current constitutional framework in terms of separation of powers and the capacity of the High Court to only make decisions on matters before the court that have a direct impact on parties. And so whether we should consider also thinking about the High Court's jurisdiction under Section 75(5) and whether it might be desirable to enlarge its jurisdiction to be able to give us the scope to make that change conclusively rather than leaving it open to some concern about the efficacy of it. So that's my introduction.
Thanks very much, Professor Rubenstein, for that. Was a comprehensive introduction.
I don't quite understand what Professor Rubenstein is saying in relation to the last point in 75(5). Are you still referring to orders against Commonwealth officials about when the Commonwealth officials deny rights? Because 75(5) is concerned with ensuring that officers of the Commonwealth do not go beyond their legal and constitutional powers.
I meant to refer broadly to Section 75, not Section 75(5).
Oh, I see.
So that we could add another, I'm so used to just referring to Section 75.
But why would it need to be an original jurisdiction? Why can't you have any court dealing with these matters with the appeal to the High Court if necessary?
Well, that would be another way.
Thank
yes.
you. That's all I have.
Thanks for clarifying that. Can I make two follow-up points?
Yes.
Is that possible?
Professor Rubenstein.
I think that Lewis's points are also underlined by thinking about statutory citizenship as well, because if we look at citizenship rights of voting and of residence, they are two of the rights that were denied to Indigenous Australians. Even though they were formally Australian citizens, they weren't entitled to the rights under the Electoral Act until 1962. They weren't entitled to free movement within the country, things that we think of as inherent rights of citizenship in a nation. So again, they sort of underscore the point that these are things that we really do need to say are protected constitutionally for all Australians and would affirm that equality. The other point I wanted to make, which picks up on the due process point, and I think also links into Professor Zine's concerns about definitions of citizenship, I do think that we would need, even if we left it to Parliament to define who would be a citizen, I think we would need to have something similar to the statement that no person should be deprived of citizenship except in accordance with a procedure prescribed by law complying with the principles of fairness and natural justice. Because there was an important High Court decision of Ame and the Commonwealth where Australian citizens who had been born in Papua were deprived of their Australian citizenship without that due process, which was deemed to be constitutionally possible because of the plenary power in Section 122 over territories. And in that case, those Australian citizens were denied residence in mainland Australia, and that was deemed constitutionally possible. They were deemed a second-class citizen by virtue of it being an external territory, of course, but it laid open that possibility for governments and parliaments to think of discriminating and creating different classes of citizenship, which I think we should, of course, not allow.
But it might then not be occasions when a person should be deprived of citizenship automatically by law, such as, say, when you're serving the forces of an enemy fighting Australia or something of that nature.
Well, that is a current provision, but again, I mean, that's setting out a clear framework for that to
It wouldn't be
occur.
natural. I mean, you're not, first of all, asking him to appear before a tribunal and give him the right to be heard and doing all that. You're just saying you cease to be an Australian citizen once you do that act. So there's no natural justice provision.
About David Hicks.
Well,
Not quite.
Yeah, I don't think it's such a big ask to request due process, even in that scenario. I think I'd rather have the baseline of requiring due process than thinking of the circumstances where it might not be necessary.
Mr. Chairman.